As a lawyer, it's always hard to confine oneself to 10 minutes.
I'll do it.
To use the analogy or metaphor yesterday of traveling on the plane, I've been on this plane for almost 45 years, and there's been a number of times when I thought we were going to run out of gas with various other proposals that have come up in that 45 years, but I do think that we are coming in for a good landing. It's certainly not a perfect landing from my point of view, but I think it is going to be a safe landing, and that we will have some bumps, obviously, along the road. So my experience with this started not long after I was called to the bar in 1972, when the interim Dane Commission report was tabled that essentially recommended that the government hybridize, create summary conviction and indictable offenses for trafficking back then, and it's only just being proposed now in some 45 years later, and that the maximum penalty be 5 years imprisonment, not 14, as you are proposing now some 45 years later. So in terms of, the public education issue, there are studies that go back to 1894, the India Hemp Drug Commission, and you can take, I think, 7 or 8 royal commissions that led up to Ledane before that. So there is more information out there about cannabis than any other drug in terms of if you want to use it for public education, which I understand is one of the concerns. I was born in Montreal, but after a couple of years, my father, who got a degree in agriculture from McGill, went out to the colonies. And so I grew up in Central Africa, and it wasn't long before I realized that some of the Africans smoked something called dacha, which was cannabis. And years later, my father told me that if he saw a marijuana plant up and around the tobacco plants, he would pull it up and throw it on the ground, as he was a consultant on the growing of tobacco. So I grew up in a situation where there wasn't this concern about cannabis and it being a problem. But when I came back to Canada and started practicing law in the early 70s, it wasn't long before I was in front of judges who would drink booze after court and pop Valiums, but they would actually sentence people to prison for simple possession of cannabis and lecture them about it. And so the hypocrisy of what was going on at that period of time was something that motivated me, certainly, in terms of the cases that I was doing. In those early days, we didn't have people growing marijuana. The market was coming in from Los Angeles, as Harlow Guthrie said, or we used to get it from Thailand and Colombia and so on. They were all big import cases. And it was only over time that the ingenuity of Canadians is such that people figured out how to grow it indoors and how to do it and create something called BC Bud, and which became popular, and we became an export economy after we had been an import economy for years. I can remember one of my first growing cases was a young man decided to grow a few plants out in his yard in Clearbrook, BC, and the police didn't know how to operate their own camera, so he helped take the pictures for them. And when we went to court, they were actually dragging the plants along the floor, and people were scooping up the material behind them. That was in the mid-70s. And so that was the nature of what was going on in terms of the production of cannabis in those early days, which has, of course, changed substantially ever since. In those early days, I used to have drug squad and other police officers come up to me and fellow lawyers and tell me I was trying to ruin a good thing by speaking out and saying, look, this is crazy for us to use prohibition in terms of this subject. And now at least I have the police coming up to me often and saying, we hope you win. So things have changed considerably since those old days. I was counsel in Malmo Levine versus and Kane, which was the challenge to prohibition that went to the Supreme Court of Canada in about 2003. I incorporated the BC Compassion Club Society about 20 years ago, and it's had senators and members of parliament and many others go through it and commented on the way it operates, including the recent task force. And I was also counsel in Allard, which you should, I understand, have a 5-page sort of summary that I put together, as well as an appendix, which are the excerpts from the court on the issue that you've asked me to address, which is the household cultivation. So in that case, well, I should step back and give you history, which probably some of you are aware of. But when the BC Compassion Club Society first started, the patients had an authorization under Section 53 of the Narcotic Control Act, which at that time authorized practitioners to give, sell, administer, or prescribe any narcotic to a patient for a medical condition that they were treating them for. And so that was the basis for the Compassion Club, which was, as I say, checked out by the police and everything in those days and allowed to continue. Subsequently, there was the Parker case here in Ontario, which determined that a medically approved patient had to be given reasonable access. And the government of the day ultimately determined that the marijuana medical access regulations was the way to do that, and that compelled people to, the only source for them was to grow for themselves or have somebody grow for them. So while we attempted to convince the government in those days that they should allow somebody to grow for more, so we'd have less grows, they said, you can grow for 2 instead of 1. And so we went back to court and we tried to say, look, we should be able to have more in one place than just 1 or 2 grows, and they said you can have 4. So we did make efforts to try and have people grow for more people so we'd have less home grows, but the number of home grows went to some 38,000 by March of 2014. So that was the situation we were faced with when a new government decided that they would introduce the marijuana for medical purposes regulations and take away that right to grow, or the designated grower, which had now existed for some 10 years. And so we went to court and we got an injunction from Justice Manson in March of 2014 that basically allowed those who had a grow license under the MMAR to continue to do so, so long as it was valid on September 30th, 2013, and those who, and their authorization to possess had to be valid on the date of the injunction, which was March of 2014. We then continued with the case, and ultimately, Justice Phelan in the federal court ruled that indeed the MMPR, the new regulations, were unconstitutional because they failed to provide reasonable access. The evidence from the patients was that they would go to a licensed producer, maybe get what they wanted the first time, then get on a waiting list and be waiting to receive in the mail their medicine, which they needed, and it wasn't working. So the evidence established that the patients voted with their feet and went to the dispensaries. Now, there were only a few of those in the early days, Compassion Club being one of them. But suddenly there was a huge increase in the number of dispensaries because those people in the business of trying to sell cannabis and make money out of it and so on figured out this was where to go. And the same then happened out here in Ontario, in particular in Toronto. So the surge in dispensaries occurred, and it established, I think, as Jonathan Page said earlier on, most people don't want to grow for themselves or have somebody grow for them. They want to be able to go to a store and be able to purchase, get information, not just wait and get it in the mail. So that's the current situation. We are I've got a minute, so I'll just jump to the topic. So in the context of that case, which deals with the entitlement of medically approved patients to have reasonable access, which includes their ability to grow, we were faced with the police, Corporal Holmquist, Chief Len Garris from Surrey, vocal opponents of home grows, going on about fire, mold, and public safety, and so on. And we established, as we do in trials after examination of the witnesses and cross-examination that they lacked credibility totally. Justice Phelan found that both Holmquist was totally biased and not to be credited, as was Chief Garris, because we clearly established that all of these things in a legal market can be reasonably done and safely done. So all of the evidence they relied upon were from the illicit market, where people were cutting corners and staying underground and not complying with anything. And so today, the inspectors that I deal with in local government tell me the last thing they want is to go back to those old days. The big issue nowadays is not a great problem in terms of fire, electrical safety, and mold and so on. They're very easy to deal with. The most common complaint is smell. And so stinking out the neighborhood, not impacting your neighbors, is a critical thing that needs to be addressed. And so I want to very quickly then close by saying that Mr. Dickey and I managed to chat a bit before coming in, and he represents the apartment owners, and I support what he says in the sense that, again, you don't want to allow people to do things where they may put their neighbors at risk or impact negatively on their neighbors. But you can't just sit back and say, well, then we're going to prohibit it, because that will not work. It hasn't worked for as long as I've been practicing. You're going to have to, I think, look at Washington State community gardens or something. Most people don't have a dwelling house as the Act defines it, with some land surrounding it and so on. So you're going to have to figure out something so that they'll be encouraged to do it in a safe place. We do have bloom boxes, which are engineered solutions, but most people can't afford them, and they'll take up most of the apartments. So I think reasonable regulation is what we want, but we're heading in the right direction. Thank you.